Hello, so today I would like to go through the defence of diminished responsibility. Calling it a defence can be difficult. It's a special defence that is only available to murder, so diminished responsibility is not used for any other crime apart from murder. So what I would start off talking about in an exam is some context to that. Because it's a special defence to murder, what the defendant is essentially saying is that I had the actus reus, so I've caused the unlawful killing of a human being under the Queen's peace. And actually, I also had the malice aforethought, so I intended to kill, or I intended to cause serious harm with my actions. All those things were a virtually certain consequence of what I chose to do. We have murder. Actus reus and mens rea, but there is a special reason, a certain reason behind your motivation, behind you having the actus reus and mens rea. Now, why is that important? Because we're saying something else influenced us, we aren't wholly culpable, we're not wholly to blame. And what that leads to is a conviction for voluntary manslaughter. Now, if you remember, murder has a mandatory life sentence. If you're convicted of murder, you must be given a life sentence. However, if you are found guilty of voluntary manslaughter, life becomes an option. It is discretionary. So you could still be given a life sentence. You could be given a discretionary life sentence, or you could be given another appropriate sentence. So, for example, a person could be given a hospital order where they are put in a hospital and they are treated. This might be more appropriate, especially for some of the conditions that might come up in diminished responsibility. So, a defendant will want to argue diminished responsibility to avoid that automatic mandatory life sentence. A little bit of background, a little bit of history there to be able to talk about, because you'll also have to evaluate the defence of diminished responsibility as well as explaining it, which I'm doing now. So it originated in the Homicide Act 1957. The Law Commission recommended that it needed to be updated. They created a report back in 2006 making some recommendations to change it. And then those recommendations, some of them were eventually implemented in the Coroners and Justice Act 2009. So if you look at section 52 of the Coroners and Justice Act, you will find the updated rules. Now, essentially, the rules work in the same way. A lot of it is just down to different terminology. So the terminology is more up to date than it would have been back in 1957. We have a better understanding of medical conditions than we would have back then. And we also use terms that are more, I suppose, comfortable or acceptable in today's law. So what must a defendant have to show to be able to be found guilty of voluntary manslaughter instead of murder? I don't know how well this is going to come up on camera, but what I've tried to do down the side here is to put an arrow. That's because these elements here must link on from each other. One leads to the next, leads to the next, leads to the next. So the first thing it says here is caused by. So we have an abnormality of mental functioning. Now, what does that mean? Well, under the old law, we used to call it abnormality of the mind. Abnormality of mental functioning is a much more clinical term, and it's a much more up-to-date term. I think it also has less of a social stigma as well. So the person must have had an abnormality of mental functioning. How does the jury, and remember it's the jury that will decide if they had diminished responsibility at the time. Remember, diminished means less than normal. So we're showing that their mental functioning was not normal. So although we've changed the terminology, we do still use the sort of questioning, the reasoning from the case of Byrne, which was before the Coroners and Justice Act, which was in, I'm terrible with my years, 1960. So essentially we're asking, was their mind, was their mental functioning so different to a normal person's that the reasonable man would call it abnormal? Now, of course, in a murder trial, the reasonable man is represented by the jury. So the 12 members of the jury would have to discuss between themselves, do we think the way that person's mind was working, the way their brain was working, is so different to an ordinary person? It is not ordinary and therefore abnormal. So that's very much a question for the jury to decide. Now, that abnormality must be caused by, so it must link to the next part. It must have been caused by a recognised medical condition. And I've kind of tried to break those down into 3 points that are worth making. So by recognised, we mean by medical experts, doctors. So it's a medical condition that other people have had, that have been recognised in sort of various medical journals, things like that. And that'll be very much on a case-by-case basis. A medical condition. So again, the updated terminology has made clear that it can be a physical or a psychological condition. So it doesn't just have to be something that physically affects the brain. It can be something that is affecting your mental health. There is a number of examples that are in the handout that discusses this, some of which were before the law in 2009, some of which have been after. But the typical examples would be things like depression, dementia, post-traumatic stress disorder or PTSD, schizophrenia, alcohol dependency syndrome, Asperger's syndrome, epilepsy, paranoia. There are a number of things, and obviously some of those examples are a physical affectation that might affect your mind. So for example, epilepsy is a physical response that affects how your mind functions, and then some are psychological. So for example, depression being the effect on your mental health. And it has to be a condition. So essentially what you could talk about here is that clearly the defendant must be able to provide evidence of this. The burden of proof is on the defendant to prove this. So they kind of have to bring it up essentially. That has to have an impact. So remember, we've got that link. The abnormality of mental functioning must come from this, which leads to this. So they must have led to a substantial impairment. Now, substantial isn't a very clear word. And so the judges have tried to give directions to juries. What does substantial mean? Well, we still use the original definition from the case of Lloyd, which is not total and not trivial. I'm still lost. Recently, the Supreme Court in the case of Golds backed up that this is the right approach, that we should be using a common sense approach. The judge does not need to tell the jury what substantial means. It's a common sense word that juries have to decide between themselves. It doesn't have to be totally impairing them. So they can still have conscious thought, but it can't just be something teeny in the background. Where the middle ground is very much up to the jury. So that substantial impairment has to impact, I don't know how well you can see this, on at least one of these three abilities we have. Now, it might impact on one or two or all three, doesn't matter. As long as it impacts at least one, we can raise this defence. So my medical condition substantially impaired my ability to understand my conduct. I just did not understand what I was doing. For example, if I was having a flashback caused by post-traumatic stress and I was a soldier and I thought I was back in the war and I start attacking what I think is an enemy soldier, I've lost the ability there to understand my conduct and to understand what I'm doing. So again, something like, for example, epilepsy. If you're having a fit, you might not be able to understand what you're doing at that time. It might be that you've lost the ability to form a rational judgment. So for example, as human beings, if you have a normal mental functioning, we evaluate all of our actions. You may want to kill, but you don't because you understand the consequences. You might want to steal that lovely handbag, but you don't because you're a rational person and you realise if you do that, it's morally wrong. You could get into a lot of trouble, you could get a criminal record, that sort of thing. It might be that you've lost the ability to form a rational judgment. So for example, if you're suffering from depression, it might be that your ability to sort of weigh things up clearly has been affected. Or you might have lost the ability to control yourself. Again, as human beings, we exercise self-control. We stop ourselves from doing things. We stop ourselves from doing things that are wrong. We stop ourselves from killing. So someone with a medical condition might not have this ability to just control what they are doing. So again, if someone with schizophrenia might have paranoid delusions and they are being told by voices in their head to do something, they may not be able to control themselves in the face of that. So as long as it's one, we can use the defense. And all of this must be the reason that you killed. So it's absolutely no good you having depression, but you killed someone because you were mad at them. It has to be all linked together. So you cannot just, carry around a little card saying, I have paranoia, I'm free to commit any murder I want. It has to be linked all together. So you must have an abnormality of mental functioning that is caused by a recognised medical condition, which then has a substantial impairment. So you are impaired, not totally, but not trivially, somewhere in between. And that substantial impairment impacts on at least your ability to understand your conduct or form a rational judgment or control yourself. And that is why you committed the murder. That is why you had the actus reus or mens rea. Those are fairly straightforward points actually, and they are usually quite easy to pick out of exam scenario questions. There is a complication. Intoxication. Doesn't want to balance. Hope you guys can still see this okay. What if the defendant is intoxicated? So for example, they've had alcohol or they've had drugs, and that can be legal or illegal. So it could be that you take a lot of prescribed drugs and that affects your judgment. I think you can tackle this by asking yourself some fairly straightforward questions. So you've read the scenario. They were drunk. Okay. Do they have a medical condition as well? That should be your first question. Is there any evidence in the scenario, for example, that they have some sort of medical condition? Well, if you're thinking no, but surely a person who is drunk is clearly impaired. All you had to do was look around pre-lockdown. I'm sure if Friday night down on the quayside, you would have seen a lot of impaired people close to kicking out time at the clubs. If you've taken drugs, you're clearly impaired, and you might not understand what you're doing if you have a drugs trip, or you might not be able to control yourself. If you're drunk, you might not be able to form a rational judgment. When it comes to eating takeaway pizzas, I don't always have the most rational judgment if I've had a drink or two. So surely they're substantially impaired. Well, no. Remember, for diminished responsibility, that impairment must arise from a medical condition. Now, if your impairment arose from lots of tequila, there may be a slightly different defense that you can use, which will come in a later handout, but it's not going to be from diminished responsibility. The root of that must be a medical condition. All right, so what if they have that medical condition? They're drunk and they have a medical condition. We have 2 for 2. Let's now look at the nature of that medical condition. Is it triggered by intoxication? Are the two linked? So for example, if you think, yes, they're drunk because of their illness. So alcohol dependency syndrome is where you have to drink. It's not just kind of something you want to do on a Friday night. It's an addiction, you have to. Then that could be diminished responsibility. That was confirmed in the case of Woods, because essentially what we have here is a person who can't help but be intoxicated because of that syndrome, because of that condition. And again, it's not just someone who likes a drink. The courts have been really, really clear on a number of cases. It's not just enough to drink lots. It has to essentially be a syndrome, a condition, recognised medical condition. So at the heart of it, were they substantially impaired by the effects of their medical condition? Yes, because their medical condition urged them to drink. What if it's nothing to do with the fact that they're intoxicated? So what if the person just happens to have dementia and they also decide to get really, really drunk on a Friday night? Or what if a person has postnatal depression, but they just fancy taking a whole load of drugs? The two aren't related. Then what do? Well, we ask the question that was posed in the Deichmann case. You don't have to pronounce it, you only have to write it. So Deichmann, the direction that was given to the jury there was, did the condition still impair them despite the drink? So kind of as well as. Basically, is that medical condition still an important factor for them acting the way they did? So if they were if they'd been sober at that time, would they have acted the same because they have dementia, for example? Or is it kind of unrelated? So they didn't do something because they have dementia, they just did it because they were drunk. Now, if they just did it because they were just drunk, that kind of leads us back to the first part. Just getting drunk is not an abnormality of mental functioning caused by a recognised medical condition. It's caused by all the alcohol. So must still be, even though that person is very drunk, the root of it still has to be their illness. I hope that helps understand diminished responsibility. Thank you for watching.